more important aspect of it is, where is that declaration first coming from? And what is that declaration which Ishaq Akwani says, please understand that. So they're assuming, not assuming, that they've written it. They said that it's coming out of original jurisdiction, civil original jurisdiction. Is that the correct answer? Is something that we need to understand. Because it stops there, then forget about the period.
And also one more aspect, because Samiullah assumes that it would be a civil declaration. It disregards what Ishaq Akwani had just noted, and it also disregards Justice Ijaz Afzal Khan's majority opinion in Panama 1, 2017, Supreme Court 265, where when he said what would be the court of plenary jurisdiction, he said it could be both civil or courts dealing with both
civil. If it's a criminal conviction, then it has automatically to be taken care of in 63, you see, so it has to be civil. Because if there is a conviction, automatically it gets sorted in 63.
No, but 63 then...
You don't have to really think about 62.
No, all convictions are not covered.
Yes, my lord, all convictions are not covered. As for example, I said cheating punishment is 1 year. Now 63(1)H doesn't cater to it, but it could be covered under 62(1)F. And there could be other instances also, dishonest misappropriation of property, 2 years. So 363(1)H doesn't get triggered, but 62(1)F could.
If it's criminal act, then for that purpose, complainant has to be considered. Who will be the complainant? If it is during the election process, then of course the election commission can submit a complaint before a court. Wherefrom, if order is passed against a person, conviction is ordered, then it will again be placed before the RO that the person so and so is.
For example, under the Election Act, there are several offences. Corrupt practices ke hai, illegal practices ke hai. Personation is one of the offences, which is deceitful, being deceitful and dishonest.
इसको तो corrupt practices में मुबशरतन में declare कर दी. It is corrupt practices. इसको उस ज़ुमरे में लेके आए.
वो हो सकता है ना sir. The Parliament is to answer.
So the question precisely is that so far the way it's coming out is that it's unworkable. In the current legal framework, no such declaration can come about. So this is unworkable. Now, what is the theory, what's the doctrine, if you see a provision which you set out to interpret is unworkable and can only be fixed through parliamentary intervention? What do we do with that provision? What do you call that provision?
I wouldn't say that it is unworkable. I would say that this provision required a legislative, a sub-constitutional
as it stands, it's unworkable unless there is legislative intervention.
In that context, yes.
So till then, what happens? What's the answer?
My lord, I think my lords may just refer it to the Parliament with their observations that this is what is required to be done. Now, and I'd say, one would think that this should have been done in 2010 itself when the Constitution, this amendment was brought in. But then perhaps, the consequences which this provision started producing was something which perhaps the Parliament at that time did not contemplate. Or after Ghafoor Lairy's first declaration, which said that it would be, the declaration would not go away with a flux of time, and then Samiullah saying this, Ishaq Akwani was leaving it completely open.
With that background.
So
but we could just refer it to the Parliament with a lighter note as a footnote that please avoid constitutional silences in future because it creates a lot of problems for the court.
It does. Otherwise,
Mr. Mansoor, sometimes it's better not to overthink things. And there's a great example from our Islamic history. Ar-Razi was a great jurist.
That's right.
And he was going, and a number of followers were following him. So there was an old woman who said, "Who is this man?" He said, "Don't you know him?" He says, "No." He says he's given 72 proofs.
A 7-member bench was hearing these proceedings as we are in 2024.
Incidentally, 7 members.
Incidentally, this question would have long been answered.
So as long as this cannot be answered, and perhaps the Parliament will have to look at it, till then F is as good as D, E and G, and they're all inspirational guidelines and they will stay in the Constitution the way it is, till such time the workability is provided by the Parliament.
That's right, sir. For now, 32(2) only provides the duration. It just leaves the procedure and manner open, and doesn't provide it.
Not commenting on the 32 because we might have different.
And Samiullah has to be overruled.
And the Parliament is at liberty even to restore the original Constitution.
I
No
wish.
problem, it will be solved.
I would hope so. I mean, about time we did.
We must hope.
About time we did.
Hey, I don't know, that's up to them. We won't tell them what to do.
I mean, it's a wish as the law officer.
Chale, are you done?
My lord, if